Hi, good afternoon or good evening, good morning, depending on where in the world you are today. And welcome to the next part of the Users Group Seminar, which is an interactive workshop concerning COVID-19 and looking how the NEC contracts can be used to deal with the problems that are occurring as a result of that. In terms of housekeeping for the session, if you can please turn your microphones off and also turn your webcams off, at least for the first part of the workshop. The idea is we will be opening to questions later. So if you do have any questions whilst we're going through the first part of the workshop, please post them in the chat forum, or if it's quite a long question or you'd like to actually say it in person, if you give your name,
is now joining.
If you can give your name, then we can come back to you and get your questions. So the first part, there's going to be a few slides. Peter and I will give some background to the issues, and then we will open it to an open forum. So firstly, I'd like to thank the event supporters who've helped us put on this conference. You can see their names on the screen there. I'm not going to go through all of those, but thank you to those supporters. We also have a sponsor today, Cypro, and we have a short film that we're going to play now. There's no sound, so don't think you're not hearing it if you don't hear any sound. Just giving some details behind Cypro, and thanks to them for sponsoring this particular session. Okay, so on to the workshop itself. So introductions. Peter, could I ask for you to introduce yourself, please?
Yes, hello to everybody. I'm Peter Higgins. I'm the chairman of the NEC 4 Contract Board. That's the body that looks after the contract and tries to make sure that we do things sensible with it. I'm a civil engineer, chartered civil engineer by profession, and I run a small consultancy advising on construction contracts. Yeah.
Thanks, Peter. So my name's Ian Heaphy. I'm a member of the NEC 4 Contract Board. I help get involved in producing the contracts and working with Peter and other members of the board to help produce practice notes and other guidance documents in relation to NEC. I'm a quantity surveyor by background and support clients using NEC in the UK, Far East, and also Australia. So in terms of the agenda for today's session, we're going to start off with a brief review of the contract provisions, looking at issues like mutual trust and cooperation, how the contract clauses are meant to work to deal with unforeseen, unexpected circumstances, such as we find with COVID-19. We'll then touch upon industry and government guidance very briefly, really just highlight that there is some out there and where that is and how you can access it. And then we'll spend some time looking at how you deal with the actual effects of COVID-19 in existing contracts, looking at how you assess time and cost impacts, how to address some of the questions that we've had fed through to us through the user group helpline. And then we'll also look at how you can take into account COVID-19 in new contracts. So contracts still to be procured, ways of dealing with that. And then we'll move into the open Q&A session, where we look forward to questions being posed by you, the audience. So as I mentioned at the start, if you have any questions, please either type them into the chat function, or if you'd like to ask the question, then simply state your name, say you have a question, and we shall come back to you for you to ask that question once we get through the first part of the session.
First thing we're going to do is just look at some of the contract clauses, some of the provisions in the contract which are relevant to dealing with problems, COVID-19 being the basis for this session, and we'll look at the clauses that are relevant to that. And we start off unapologetically with clause 10.2, acting in a spirit of mutual trust and cooperation. The parties, project manager, those involved in the contract are expected to work together to deal with things that happen. And this is quite crucial in terms of how you deal with this. There's no possibility that you can sensibly deal with this kind of problem by putting yourself in a small room and isolating yourself from everybody else in the contract. work together to solve the problems. And of course, the early warning process is designed exactly to deal with that. Meet up, talk about the things the problems you've got. Look at how you might deal with them. What are the options? What are the possibilities? How can you do things? Discuss it, sort out the best way of dealing with it, agree the right approach to dealing with it. Clause 15 is designed to help you to deal with that problem. Now, we come to clause 17, an interesting one, impossible or illegal requirements. And these are pretty strict tests, really. By illegal means you can't do it, not that it's going to make it more expensive to do or take you longer to do. Impossible, same point. So it's only got a certain amount of impact on things like COVID-19. Many things are illegal, but whether it stops you, whether they are truly illegal or whether they're a recommendation that you should follow, and whether it's impossible to do things is a test you've got to apply if clause 17 is going to apply. And the procedure in clause 17 is if there is a problem like that, the project manager has to take some kind of action. Ian.
Yeah, and one clause that has been quoted a lot in relation to COVID-19 is clause 19, prevention, which it's similar to a force majeure type clause in other contracts. It's an event that neither party can have foreseen, neither party can prevent, and has an impact upon the progress of the works. That impact, though, has to be in effect on the critical path. It has to delay the actual completion date. So a delay that can be recovered would not fall within clause 19. It has to be an event that causes a delay to the completion date or means the completion date cannot be achieved at all. And as we'll discuss later, there are duties on the contractor to try to mitigate it, but in many cases, clause 19 will be applicable. COVID-19, not an event that people could have foreseen, not an event that people can have stopped impacting the works potentially, and that will have a delaying effect of a significant nature that it will delay completion or stop completion being achieved at all. And I think just one real key point to make around clause 19, Peter's touched on this already to an extent, is on the back of prevention being, if you like, identified, it's for the project manager under the ECC, similar person under the other contracts who's managing it on behalf of the client, to take control of the situation, to actually then give instructions on how the event should be addressed, how best to deal with it. And I think, come back to Peter's point around 10.2, we don't want people putting their head in the sand here, whilst acknowledging it's a clause 19 event, there's no instructions on how to deal with it. It's sort of, the people are standing back and just seeing what happens, when actually we want the project manager to take control of the situation through things like early warning, speaking with the contractor, agreeing the best way forward, so that the consequential effects then are much easier to deal with because that course of action has been determined, has been agreed in advance of then having to do things like assessing the impacts of compensation events. We also have clause 34 in the contract, which I know has been used in different parts of the world. So that is a instruction to stop or not start any work. So where we have that situation, sometimes clients have stepped in, particularly where it's government bodies, and have actually given a stop order for works to avoid the risk of spreading COVID-19. That will be a compensation event. And again, as part of that instruction to stop work, a conversation needs to happen around how long for, how do we restart, what do we do about demobilizing site or remobilizing? And we'll touch on that later, but with all of these, it's that need to be proactive in agreeing the actions that follow from these instructions. We also have X2 as a secondary option, so that may or may not be included in a particular contract. It's optional, but where X2 is selected, where there is a change in the law of the country where the site is located after the contract date, that will also be grounds for a compensation event. But obviously that has to be a change in the law, not just recommendations, not just guidance, but actually a change in the law of the country where the site is located.
Now, it may be that having looked at all these, the right course of action is something which doesn't fit with them very well. Maybe there's a cash flow issue, or maybe you've decided that, well, let's just take a particular action which doesn't get properly compensated or dealt with under the contract. But we need to record it in some way. We need to agree it. So it's no good simply having, say, an early warning meeting saying, agree what we're going to do, and the project manager recording it. Under this contract, clause 12 requires that to be in writing and signed by the parties. Now, it can be signed in various ways. There's no problem about doing it electronically, for example, but it must be that the client and the contractor agree in writing to this particular change. It can't be something that's done orally and recorded by a third party, the project manager. So if you do agree something, and we're going to touch on some of those a little bit later in a few minutes' time, if you do agree something which is not covered by the contract, you need to modify the contract to make it effective. Otherwise, you're lining up problems for the future. Clause 12.3, very clear, must be in writing, must be agreed by both parties and signed by them.
And Peter, just picking up on a comment that Ross Hayes has made around the fact that the prevention clause only exists in certain contracts, primarily the project contracts where we have an end date. So the PSC, the ECC, etc. It doesn't appear in the term service contract. So there may well be a need to look at things beyond the standard contract mechanics if required to deal with the event, where clause 12.3 could then come into play.
Indeed, yes. One would look at the way to deal with the problem and be aware of what's in other contracts and take action to deal with it. Project manager needs to look at it. With all of these things, the project manager is really in control, because the project manager is looking at it to see what is the best course of action in order to preserve the client's long-term interest in this project.
Yeah, and the same with the service manager under the TSC.
Yeah. Moving on to guidance. Industry has given some guidance and the governments have given some guidance, so we'll just touch on that a little bit. We start off with the NEC guidance. We published some guidance which is on the website, a document which is produced to explain the impact of COVID-19 on the contract. There's also been some videos that I've done and Ian and I have done to give some guidance of that. You can get access to all of that through the NEC contract website. There's also the opportunity of getting further guidance and assistance through the user group help desk. Those of you who are members will be able to send a query to the help desk asking for advice on a specific question. We can't deal with specific questions in this session, but the help desk can. Now, other industry guidance is given by the UK Construction Leadership Council. This is a quasi-government, it's an industry-led organisation which includes government, and they've published a number of guidance, but the particular ones are site operating procedures. They're now in version 4, which is trying to tailor it to suit changing circumstances on sites. Very useful document spelling out how the site can be operated in a safe way under current conditions. And they've also given a statement on payment and contracts. They're trying to encourage people to be sensible. Now, we've also got some UK government guidance. It doesn't apply uniformly across the whole of the UK, because different parts of the United Kingdom have different approaches, slightly different way of dealing with the same thing. And of course, it doesn't apply outside of the UK, but it does give some useful, interesting insight into how government is dealing with it, which could well be of influence in other areas. So we've got, key one is a policy note 20, which gives supply relief due to COVID-19. This is really providing extra contractual remedy where the contract itself isn't going to adequately deal with the problems that the COVID-19's caused. Ian's going to explain that a little bit more in a moment. But then there's also another government document, which is very, very interesting. It's COVID-19 and responsible contractual behaviour. This is really saying, don't get in the idea of looking for loopholes, way of not paying or way of claiming extra. The idea is to try and manage the contract in a sensible way, apply the contract rules, but don't start looking for loopholes to get out of things. This is a joint problem. Look for a way of solving it and do it sensibly. And then also there's another document which has been produced by government, working safely during coronavirus for construction and other outdoor work. Not specifically on construction, but for anybody working outdoors, which links, I think, back into the Construction Leadership Council document. Ian.
Yeah, so I think, as you already mentioned there, Peter, the UK government has produced some helpful guidance there, the Policy Practice Note 0220, around how to deal with the effects of COVID-19, particularly focusing on how to protect the supply chain, to make sure that we can retain the skills the people available to restart work when required. And that has evolved over time. And I know that just recently we now have PPN 0420 that's been issued, and that's about how to transition and move from the state of lockdown that we've had to how we then restart the contracts, how we look to get people back on site. Also considers whether actually do we bring these contracts to a close if necessary. So there's useful guidance there that explain how behaviours should be, what behaviours we're expecting from the supply chain, back to the sort of idea of fair dealing between the parties. Now, obviously, we realize we've got an international audience with us today, so these are UK specific, but just really trying to say that there is guidance in certain jurisdictions. We know in the devolved parts of the UK, there's different guidance being given, and in different countries, different organisations are also providing similar guidance, and they're useful things to use to try and get some sort of consistent approach within those jurisdictions.
Can we move on to the next slide?
Yeah. Okay, so in terms of existing contracts and how we deal with COVID-19, we've already identified that we have a number of processes in there around how to deal with COVID as an act of prevention. As we've mentioned, that only relates to the works contracts, if you like. It doesn't relate to the TSC, for example, but prevention's in there that can lead to a compensation event. As Rob Gerald has just pointed out, when we're talking about delay in that instance, we're talking about delay to planned completion. So that will be as evidenced on the accepted programme. So key that we do have these programmes updated and regularly accepted to give us that completion date to assess whether we have an act of prevention occurring. Do we have an instruction to start work or not start work? That obviously leads to a compensation event. And it may also be that we simply have changes to scope. It may be that the client and the project manager decide to make changes to the scope, maybe place additional constraints on how the work is undertaken, maybe change some of the requirements around what that work is going to be, which again would normally lead to a compensation event. So there's a number of ways that we can get ourselves into a situation where we have a compensation event. And then once we start into that process, the NEC has a number of tools we can use there to try to get to a determined outcome for the time cost effects that result. So this again links back to things like the early warning process. It leads to instructions and agreement over how to deal with the event. And some tools we have there, clause 61.6 allows the project manager to state assumptions when asking for a quotation from a contractor about the impact of COVID-19. So that could be, for example, saying, assume the delay is for 3 months. And if it goes on longer, we'll issue another compensation event for the additional period. Or if the period is reduced, we can issue a negative compensation event. But it gives some parameters, it gives a basis on which a quotation can be prepared without, now, whilst we can still assess it and try and ascertain the impact in advance rather than trying to deal with things retrospectively. One of the key things, I think, is clause 62.1, which gives the options for how you deal with the effects of a compensation event. And this is very much linked to things like the early warning process, having meetings. How do we best deal with the effects of the compensation events? So if we have identified prevention, there is going to be a delay, or there's going to be a stoppage of work on site for a period. How then do we deal with it? Do we remove all the staff from site? Do we furlough them? Do we look to reduce staff numbers and then re-employ later? Do we maintain the staff so they can restart if we want an immediate restart at some point when the COVID restrictions are lifted? Are we going to maintain key subcontractors? Are we going to keep certain equipment on site? Because to off-hire it is difficult, could be more time consuming and more difficult to then get that equipment back. And these are the conversations that you can have and you can debate and discuss to come up with what hopefully is the best answer for the client, whilst also protecting the contractor. So 62.1, I think, is a key thing. And that also gives the project manager the power to instruct certain ways of dealing with it. And that is how you assess the compensation event. Linked to that, we have clause 63.9, which creates a duty to mitigate for the contractor. So when the contractor is looking at how they respond, there is a duty to mitigate. But that duty to mitigate, again, has to be looked at in the bigger picture. Whilst the duty to mitigate may be, well, contractor, get all your staff off site, get all your workers off site, where possible, make them redundant or remove them from your organization. Whilst that may sort of save costs in the short term, that's going to cause a lot of problems in the long term. You're going to have to re-employ those people. There's going to be redundancy costs. There's going to be, a human element to it as well. So there's different ways you can debate and discuss how best to mitigate those costs. And that should be part of an involved conversation between both the project manager and the contractor, and not just either party deciding unilaterally what to do. Having this conversation as part of the early warning process, as part of clause 62.1 linked to 63.9. Peter, you got anything you'd like to add on that particular issue?
No, I think that's fine. It's the duty to mitigate is quite important, and we'll touch on that a little bit, I think, in terms of questions about resources not used to provide the works. So I think let's just look at these other points you got there, which I think is quite a critical issues to deal with.
Yeah, I think it's interesting that obviously questions that have come through to the NEC, a lot of them have been around things like working areas, around the schedule of cost components, around what provide the works means. And certainly when you have to look at this, I think, as a whole. So when you look to things like costs have to be incurred in order to provide the works, well, provide the works means complying with any instructions given. So if there's an instruction given, which is to stop work, there could be a follow-on instruction. And what do we do about the resources on site? If it's agreed those resources are going to, in effect, be on a standing time basis, so whilst there's no work happening on site, we still want those workers available. We still want them to be able to restart as and when required. Then they are, in effect, providing the works by complying with an instruction to stand down. And I think that links back to a heading of disallowed cost, which talks about you disallow the cost of resources not used to provide the works, but after allowing for reasonable availability and utilization. I think we all can understand that on a construction site, and even under term service contracts providing a service, there may be breaks. There may be situations where work can't take place for a period. Maybe there is a short-term instruction, stop work. So there's no one actually working at that point, but you still maintain the equipment on site. You still maintain the people while decisions are being made. So that, I think, is still providing the works, but we have to counterbalance that with this reasonable availability and utilization. So if the job is stopped for a month, maybe you retain all the equipment on site. If it's going to be stopped for 6 months, maybe you look to off-hire equipment. But that's got to be part of the conversations through the early warning process, and also linking into 62.1 and how you deal with the different ways of addressing the events, the circumstances. Another issue that has been raised is around working areas. And that is quite interesting how that's dealt with in NEC 3 and NEC 4. NEC 4, starting there, the definition or around how you claim costs for people in the schedule of cost components was changed slightly to say that people who are normally based within the working area can still be charged as part of defined cost, even if they're not in the working area, as long as they are providing the works. So that actually gives a way of saying to people who are maybe working from home or are just at home, can't work on site, could still be charged to the cost of the project as part of defined cost. It's either as part of a compensation event or as part of defined cost payment under options C, D, and D of the ECC, for example. NEC 3, slightly different. NEC 3 does have this requirement that for people to be charged, they have to be within the working areas. So that can obviously cause an issue if staff, people, labourers, etc., are not within the working areas now. They are working from home. How can you deal with that? Some people have suggested extending the definition of the working area to include people's homes. You could do that. It would have to be a change to the contract, 12.3. But I think in fairness, there's a risk around that you then open up potential discussions around what about the cost of the IT equipment in the house, the cost of the broadband service, the cost of the phone bills for the house, because that's now classed as working area. So it may be better just to agree that certain costs can be charged for people who are outside of the working area and deal with that through a change to the contract under clause 12.3. Any views on that, Peter?
Well, the thought of that one is that if the client and contractor can't agree to a process such as that, then the option of keeping people on standby disappears. The contractor would have to effectively lose the staff or take them away from the contract, make them redundant or use them elsewhere, which means that they're not going to be available for restart if that was the intention. So there's pressure on both sides to reach a sensible agreement over that on an NEC3. We've solved the problem in 4 by the way that it's been rewritten, but there is a need for people to get together and use this technique that this clause that I mentioned, of clause 12, of making a written record of the agreement to make that payment.
Yeah, I mean, just related to this, and just some questions that are coming through in relation to things like in the UK, the concept of furloughing staff, where the government has stepped in and said that they will pay salaries up to 80% or £2,500 a month for certain individuals. You know, I think as a contractor and the project manager, you work through the process. Okay, if there's an instruction to stop work, if it is a prevention event, if you have X2 change in the law and there has been a change in the law, not guidance, then how do you deal with it? And as you said, Peter, do we, make staff redundant? Do you keep staff on board? How best do you, as a team, decide to deal with the event? It may well be a conversation is had that, yeah, actually the idea would be for the contractor to take their people off site, to maybe furlough those who are not able to provide the works. And then the client just pays that 20% top up to the contractor. Or maybe there's an agreement that the contractor will just claim the furloughed amount, and that's the most appropriate way to deal with it. But those are the conversations that need to happen as part of the compensation event process. Certainly, I don't think we'd expect to see a situation where the contractor was getting the government furlough and then charging the full cost of the staff to the project as part of defined cost, because that's not a cost they're actually incurring. 80% of that cost is being met by somebody else, i.e. the government.
Yeah, I think if you look at the schedule of cost components, the way of payment for people, you can't claim that 80% if it's being paid by somebody else. It has to be money that the contractor is paying out for that person. Well, if the government is paying it out, effectively by reimbursing the contractor, then the contractor is not paying it, so you can't recover it.
Yeah, and I don't know, clause 52.1 may come into play there as well, with this concept of any discounts, rebate, taxes being recovered, being given to the client, or the client getting the benefit of those. Again, maybe it's not an exact fit in these unprecedented times with the use of furlough, but I think it's a similar principle that we're trying to, in a compensation event situation, put the contractor in the position they would have been in if the event hadn't occurred. So if they're not suffering the 80% cost themselves, they shouldn't really be claiming that.
Sure. Yeah, we're getting quite a lot of questions coming in on some of these things, so maybe we just need to start looking at some of these questions shortly. So, yeah. I was going to talk about you've got some more points on this one.
No, I think we can move on now to how we deal with it in new contracts, and then we can go back to the questions. Okay.
So those guys, you posed a lot of questions. We'll come back to those and try to pick them all up, or as many as we can. But just quickly now, final slide, just to deal with new contracts. If you don't have a contract today, but you're looking at putting one together or about to consider awarding one, how do you deal with the problems due to COVID-19 in this contract? The first bullet point up there, contractor's risk. There's a question mark there for a good reason. You could simply say to the contractor, look, we know there's a problem with COVID-19, your problem, you solve it, and give me a price for dealing with it. If you really want a contractor who's a gambler as your contractor on the site, then that's one way of getting a gambler on board. But the problem there is that the contractor's going to make assumptions about how they're going to do the work. When do they believe that certain restrictions are going to be lifted? How long do they assess the problems are going to go on for? How long is it going to take them to build the work? So they're making speculative guesses on this future. They've got no way of knowing any more than the client does. So they're going to make a guess. if the guess is wrong, the contractor is going to have a problem, which is going to turn into a client's problem. So simply posing the risk to the contractor doesn't seem a sensible way forward at this stage. So the question is, how do we deal with it if we're going to try and do it sensibly? Now, the first point is we need to be very clear in the scope what you're expecting to happen. It's no good simply saying, well, these are the restrictions, now give me a quote for dealing with it, because do you assume the restrictions continue forever for the life of the contract? So this 12-month construction project now takes 4 years. Is that what you're actually asking for? No, you need to state some assumptions. Let's assume that the current restrictions change in 3 months' time and they're changed to this kind of restriction. Or do we simply say, assume that all restrictions are removed at the end of 3 months and there are no restrictions at all? Because if we're looking to state a compensation event, we must be very, very clear what we're going to compensate for. We want to say, this is the model that you're to price on, and if it's changed from that model, then there will be a compensation event. So it's pretty important to get your scope, your details in the contract as to what you're expecting to happen, how you expect the contractor to go about doing the work, so that everybody's quite clear what is wanted at that time, and then including that, any process you need to put in for sorting out how you're going to handle the changes. So if there is a interim position which is different from one you've allowed for, how you bring that into the contract, how you deal with it, who does what at what stage. You can then deal with the compensation event, and I think certain people are looking at trying to draft some kind of model or guidance on this, and it could be that some guidance comes out in future, but maybe I'd be very interested in hearing experience of people who are perhaps preparing contracts now as to how they're going about it. Is it so important to award a contract in this uncertain time that you need to award one? If so, how are you going about it? We'd like to hear that. I think it'd be a useful discussion point. Anything to add here?
No, I don't think so. Again, it comes back to the idea that we can't ignore it. We can't pretend it's not happening. We can't just think, let's award a traditional NEC without taking into account this risk issue, because it is going to have an impact. We know in the foreseeable future. How long that lasts, we don't know. But I think you do have to take that into account. And the sooner you can have the conversations with your bidders, if that's possible, depending on the tendering process, but thinking consciously how you're going to deal with the issue. I mean, Rob, Gerard just posted there around maybe you can delay tendering the scheme if this, if you can. Maybe you can let an initial enabling package of work. Maybe this is where you could use the secondary option for early contractor involvement to get somebody on board to start to work on it in a stage 1, stage 2 approach, depending on the nature of the work. So, there are options available, but if you are, or you do have to award a contract in the near future, you have to address this issue. You can't just ignore it and think, well, we'll just deal with it later, because that's going to cause issues.
Okay, moving on. I think we now move on to question time, don't we?
Yeah,
yes.
I think we are. And there's a number of questions that are coming through. One I'll pick out. Forgive me, I'm not going to try and pronounce the first name because I'm not quite sure how to say it, but it was somebody from Arcadis raising a question around clause 61.6 and stating assumptions. And as we know under the contract, if a project manager states an assumption, if we then find the assumption proves to be incorrect, we issue a compensation event to deal with that, the difference between what was assumed and what's happened. And that could be a positive or negative compensation event. But the point being made is that when it comes to time, if you agree, if you say in your project manager's assumption, assume it's a 2 months delay, if it turns out to be a shorter delay, you can't actually change the completion date back. Completion date can only ever be extended, not reduced. So it's a very, very good point that's been made there. I mean, obviously 12.3 could possibly come into play, but I think the view we have from NEC, and Peter, I'll let you sort of jump in a second, is that where we have an assumption around time, if we say to a contractor, assume it's a 2 month delay, if we then find out actually it's only 6 weeks, not 8 weeks, to suddenly turn around and say, right, you could have started 2 weeks ago, or you could start tomorrow, therefore a negative CE for those 2 weeks, may not really be fair, because if the contractor is planning to restart in 2 months, maybe has furloughed staff, maybe has mothballed certain things with a start date. Just because they could start early doesn't mean they actually, that could happen in reality. So when we do agree a revised date as part of a compensation event, that's what the contractor is then working to. And if they can finish earlier, great, but we don't pull that time back.
Yeah, this is a fundamental point about NEC, is that we don't shorten the time for construction at the project manager's whim. If the timing does change, then it may be the contractor can't actually pull anything back or can't do it efficiently because he's organised himself ready to do the work at that time. But there is a process in the contract to deal with it. If you really want to try and bring the date forward, we've got the process of acceleration by a quote which is accepted. So it's not something that you can force on the contractor, but if the contractor and client can agree, or project manager can agree, a sensible price for bringing the date forward by compensating for the change of the cost to the contractor in doing that, then we can use the contract process for doing that. You don't need to go to clause 12. The contract already includes that provision. I think that also deals with Sanjay's point, doesn't it? Can we also have a conversation for a period and ask PM to state the assumptions and change when the situation changes? I think that happens is that once you've made assumptions, if those assumptions are different, you change and you deal with the new compensation event, and you may need to state fresh assumptions.
I think that point is there, though, that negative, if we do have a negative compensation, it will be in relation to the cost effects rather than the time effects. But again, as part of that process, it's discussing with the project manager, clause 62(1), how best to deal with it. Do we just week by week, month by month, try and look at what the delay will be? Do we say it's 3 months now? Do we say it's 2 weeks, and then as we get nearer that, another 2 weeks? We have to bear in mind that the contractor's not working in a vacuum here. They have to plan and think and be prepared to restart and resource at a certain point in time. There was a few other questions that came through around the furlough and the 80% to the 100%. I mean, it's difficult to be specific, as we discussed earlier, in relation to some of the questions and not having all the facts necessarily. But I think the view, certainly my view, would be that when you look to the contract, it says that the contractor can claim as part of the impact on the prices, the defined cost incurred or a forecast of defined cost to be incurred, takes you to the schedule of cost components, takes you to the cost of people, and the entire cost of people can be charged as part of that that item in the schedule of cost components. So for me, the default is there's a right to charge the entire salary costs, but then if you're getting 80% of that back from the government, that would then have to be sort of discounted or taken out of the amount being claimed. Otherwise, you'd be recovering the same amount of money twice. And as we discussed earlier, that's not the intent. Again, it may be that as part of a conversation, the clause 62.1, you say to the contractor, yeah, there's 100 staff, are we going to furlough some of these, all of these? Let's agree the best way forward. Are some people that maybe, contract staff that we could not have to use, but maybe they've got specialist skills you want to retain. And so the idea is really to try and agree what you think is the most appropriate way, capture that as part of the instruction, and then there won't be arguments later over who's paying this or who's responsible for that. You've addressed it up front. It's that classic thing with the NEC that we need people to make decisions. We need people to agree rather than, well, actually, bit of a tough question. Let's not deal later. So agree and avoid problems later. Okay, again, there's another question in relation to the furloughing there. Could it be a temptation for a target cost to not furlough? But for me, that comes back to this conversation around how best do we, project manager and contractor, deal with the event. If a contractor is not going to furlough their staff, is then going to have hundreds, maybe thousands of people who are going to be charged to the project for an extended period of shutdown, you may then get the project manager talking around, well, is that a disallowed cost? Is that resources not used to provide the works after allowing for reasonable utilization? What's reasonable in that context? And that's, again, where having these conversations up front will avoid arguments later over why didn't you furlough? Or, why did you retain these numbers of people when actually some of them were no longer required. You could have actually maybe off-hired them. I think we look at people very differently to equipment, but the principle's still the same. If you've got equipment on site, like a tower crane, and you've got a period of suspension for COVID-19, are you going to off-hire it? Are you going to take it down and remove it? Is that really sensible and practical? You probably keep it on site. There's a cost to the project whilst it's there, because it's not working due to an instruction of the project manager to suspend works potentially. So this again comes back to that conversation that needs to be held to decide the most appropriate way to deal with the event, bearing in mind the duty to mitigate, bearing in mind that there could be a disallowed cost if resources are kept on site unnecessarily.
There's one here from Montgon at West London NHS. What happens if the contractor is able to replan the works to recover lost time but incurs cost? How does that fit with the prevention compensation event? So in other words, it doesn't delay, doesn't stop completion, but it just causes the contractor to incur additional cost in achieving it. How does that fit with compensation event and in fact for clause 19 as well?
I think it goes back to Peter, I think it's back to the discussion we've already had to an extent, which is, prevention. If that occurs, then the project manager is able to decide how best to deal with it. And maybe in conversation with the client and hopefully engaging the contractor as well, maybe there's a decision taken that actually, if we can shuffle these things around, if we can do some additional things, we can mitigate the delay. It'll cost us more. But maybe that's what the client wants. That's the most appropriate for them. The project manager gives instructions to that effect. When you come to price the compensation event, you can look at pricing it on that basis. That's the agreed way forward. That's what the clauses and provisions are there for. Maybe alternatively the client saying, actually, I'm building a new hotel. There's going to be a lack of demand for months to come, maybe longer. I'm not in any rush to actually get it finished now. So maybe I'm prepared to extend the time and have a longer period of shutdown, because actually I'd rather do that than incur any additional costs in lots of reprogramming the works or double shifting to try and recover a time position. And that's the whole idea of the ability to issue instructions in relation to prevention, instructions to stop or not start any work, and then to agree how we're going to deal with the effects and price that as part of the quotation process.
But the question that comes to mind though, Ian, is how do we draw the line as between an event which stops the contractor from completing the works by the completion date and an event which will cause the contractor to incur additional cost in completing the works by the completion date? It may be that if in fact it doesn't stop the work from completion, but simply makes a bit of disruption to it, that it doesn't fit with the clause 19 and doesn't become a compensation event. So there's a question mark behind that as well. So it's a question of degree. It may be possible to do something tuning around the edges, but your starting point, you have to be in a position where you've actually caused that kind of impact on the works in the first place.
Yeah, I think again it comes back to looking at the event. If we don't mitigate or do anything, would it cause delay? In that case, you're looking at an active prevention, I'd suggest, but other characteristics being met. If you then pull it back and say, actually, if we do this, this, and this, we can mitigate the effects. Well, in that case, surely you're now saying it is prevention, but we're going to mitigate the impact by doing those other activities.
Yeah, I think we need to be cautious about the word stops the contractor from completion of the works rather than delays the contractor in completing it. And that's the critical thing, I think, behind clause 19. It is quite restrictive. It's not meant to be a simple catch-all which says if anything unexpected causes a delay, you get compensated. It's got to stop you from completing the works. It's got to be quite a significant one.
Yeah, I think we've got a couple of people with their hands in the air. I seem to ask questions. So Richard Patterson, have you got a question you'd like to ask?
Yeah, Ian, thanks for the presentation as ever. Well, my question was that we've seen all this government guidance that came out, trying to be nice to contractors, don't screw these poor little contractors, and it seems that there is now CLC guidance, which the issue, of course, it's not law, it's guidance. But would you agree that any contractor who's a director and is supposed to be looking after their people has no choice but to comply with this guidance? And if so, why? That's not your question because you're not government, but why did government not just say, tell your project managers to instruct compliance with that guidance? That's a compensation event, sort it out. We shouldn't be spending time fighting over whether or not it's stopped or just made a little bit more difficult, a 60.119 compensation event. There's going to be so many disputes on that. It's just ludicrous. That's what I've been suggesting clients should be doing if they're going to be realistic and say that no contractor included in their price for COVID, full stop.
Should not that question be addressed to your Member of Parliament rather than to us?
Quite possibly. I quite like. Well, I tried to get that one in this morning to some various governmental figures, because I read all these PPNs and they were lovely. It'd be nice to contractors and see if we can find ways to make it pay them money. Well, use the bloody contract. He's got a compensation event. Sorry, I'll stop now. It's my whinge. It's my rant.
I think, in fairness, it's difficult to give guidance that is just universally applicable, even in the situations of COVID-19, in that, some work can continue on, maybe some work is not affected, other work is hugely affected.
But all that will be determined in the assessment of the compensation event. But the brave thing is to admit that this is a compensation event, and that's what I find it ridiculous that particularly government clients are not doing in some cases. Because every government client around the country is now writing their own guidance on how to deal with COVID, despite the fact that there's these PPNs out there. Anyway, sorry, move on.
All I was going to say, just close out on that, I do know that there are certain clients, both government, quasi-government, who have been proactive, who have given instructions, who have said, stop work until, for a period of time, who have said, let's change the scope to bring in additional restrictions, etc. So, some are doing it, others are not doing it. I think, as we keep on saying, you can't just bury your head in the sandy. You can't pretend, this isn't an issue. And the sooner you get it on the table through an early warning meeting to discuss it, the better. And then hopefully parties will sensibly deal with it. But obviously, at NEC, we can't make that happen. We can only sort of encourage people to have those conversations to at least start the process.
There's an interesting question here which highlights one of the problems you get through changing contracts. Miele Suffrage has raised a query and they said, well, assume that X2 is in the contract and the law's been changed, which could be seen as a consequence of COVID-19, and that's a prevention event. And then there's a Z clause being written which removes removes cost and pays only time for a clause 19 issue. Now, what happens then? Well, if you've got a contract with a Z clause which has confused things, then I think there's a bit of a problem there, because we have one clause, X2, which says that the compensation is due. Another clause, Z clause, which says if it's under this particular clause, no compensation is due for payment. For payment, you only get time. Then you've got two clauses which potentially clash. And this is where the lawyers need to be a little bit cleverer than they are in terms of dealing with Z clauses, in making sure that they mesh their contract clauses correctly with what the contract says. I think there could be a little bit of a debate about whether or not you can recover costs in that situation. So it's a question mark as to what the contract actually says, the detail of it, how it's been written, and obviously we don't comment on that. But if you have a Z clause which affects one clause in the contract but leaves another one unchanged, then there may be a bit of an issue. And I think that's perhaps the problem here.
Peter, another question that's come in from James Rook at Skanska was around when government support ceases for COVID-19, but there's still ongoing impacts and effects, in that maybe we're now all back to work, restrictions have eased, but there are still consequential effects of that stoppage or the restrictions at the earlier points in time. How can they be addressed as part of the compensation event process?
Well, I hope they will have been addressed through the assumptions stated. So there will be certain assumptions made in order to provide a quotation for the compensation event, which will then either have been correct or be wrong. Now, if the assumptions are wrong, then a fresh notification of compensation event and procedure to deal with the changed circumstance will be taken into account. So if in fact you've made a certain statements as to when you think things are going to change and they're different, that itself becomes a change in the assumption stated.
Yeah, I think that's it, isn't it? That when we look to assess compensation events, we do expect the entire effect of the event to be assessed as part of that compensation event. We don't have claims or other compensation events to be claimed later, and that's when you're going to have to use assumptions around. Yeah, when do we think the effects are going to stop? What do we think the new normal will be? So I think all we can do is work through that as part of the quotation process, using assumptions where necessary to plug any gaps in knowledge.
Yeah. Ross Hayes asked a question about was the government instruction to stop work on sites a legal act? And if so, clause 17. I'm not sure the UK government did give an instruction to stop work on sites, did it? I think the Scottish government did something in terms of restrictions, but in England, I don't think that was the case, unless I missed something. I mean, if a government did say an instruction came out from the government which says all work on construction sites must stop, and that was given under the authority of Parliamentary Act, then certainly, yes, that would be covered by clause 17. But whether in fact it's happened is a question which I don't think I can answer today.
I think, Sanjay, have you got a question you'd like to ask us? Well, so Sanjay's got his hand in the air. I'm not sure there is a question there, but if there is, please let us know. If not, we'll go back now to the questions that have been posted to us. Yeah, some of are on a similar theme. We do have, we need to look at the exact circumstances. Which governments in which parts of the devolved parts of the UK gave instructions to stop or not start any work. Some were, I think, clearer than others. Some made a much more definitive statements and actually did give the instructions to stop, which makes it nice and simple in one way. But, really, I think even where the government hasn't given strict instructions, you've still got the early warning. You're still going to have a conversation. Again, I think, even without that formal instruction, if there is an impact caused by dealing with COVID-19, then that should be being raised as the early warning and hopefully being dealt with through the processes within the contract. And it does come back to both parties actually coming together to have that conversation.
Do we want to try again with Sanjay, see whether Sanjay...
I think he's got an issue with sound, I don't know.
Yeah. No? No.
Okay, sorry, Sanjay, we can't hear you.
Oh,
hello?
Yeah, hi, Sanjay here. Can you hear me now?
Yes, we can. Yes.
Okay. Sorry about that. This is about what we were discussing earlier about the time and cost when the assumptions are changed. So let's say my project manager asked me to stop the project for, let's say, 13 weeks. However, after 10 weeks, if I received the start instruction, so which is actually taking a month out of earlier compensation event we submitted for an assumption of longer stop period. So if we are not pulling the time back, then how do we calculate the negative compensation event? So does it mean then that we don't change the time and cost submitted earlier, but we just treat that as an early access to the site? Is that?
Yeah, I don't want to be access per se. I mean, if you already started work on site, you've already been given access, then that event has happened and access has already been given. I think, again, I'd look at the exact facts, but if you've been told to stop work and to assume it's a period of 12, 14 weeks delay, whatever, and then as the contractor, you plan on that basis, if then that assumption changes and work can start earlier, we can't go back and change the time assessment of the compensation events. If that delayed the completion date, that completion date will remain changed to the revised date as part of the quotation process. But if you then could start earlier, if that means then, for example, you'll be on site for a shorter period, maybe there are reduced costs because you will actually physically finish earlier, that could be part of a negative compensation. So the prices could change, but the completion date could not be brought forward to an earlier point in time if you were given an earlier restart date. As Peter mentioned before, you could agree that through an acceleration, and maybe an acceleration at no cost, but that would need mutual agreements. Really what we're saying is the completion date would remain as changed on the back of the original compensation event. If there is another compensation event because you were given this earlier access to restart, we would assess any savings in terms of money that creates, but you would still have the same time to work within. You know, it's that fundamental principle we've already mentioned, that we don't reduce the time for construction, we only ever extend it through the compensation event process.
Okay, yeah, so by that process, then we might just get the increased terminal float, and
Yes,
that's it.
Yeah.
Okay.
Yeah.
Okay.
Yeah.
Understood. Thank you.
Okay, thank you for the question. If anyone else has got their hands up and I haven't come to you, please do maybe just type your name if you've got a question, because with the show hands, it's not always easy for us to see exactly who is raising their hand. So if you have a question, maybe just drop your name and just say your name, you'd like to ask a question, and then we can come to you.
Just a quick one, Richard, jump into a quick one. Richard Patterson there, would you agree new contracts you choose a compensation event for COVID worse than at the contract date? There's a big problem with that because COVID could be much easier than at the contract date. So as restrictions are lifted, it gets easier. So how do you deal with those? Anyway, moving on, you got a question there, Matthew?
Okay, I mean, there's
three things.
Sorry, go on, Matthew, please, sorry.
All right, sorry, my chat function isn't working, which is why I'm asking the question verbally. So we've had a number of conversations with a contractor on a live project, which we had to instruct a stop of. And this relates to the providing of the works clause under the shorter schedule of cost components in NEC 3. So we have agreed that we will not pay for operatives of the site that are furloughed. The contractor's taken a view and looked to mitigate that cost by furloughing staff. But there's a period of time between the shut of the site, when we instructed works to stop, up until the point of furlough of about a week for a number of operatives on a large site. How are we best dealing with whether that cost should be paid or not? Or is that just something we have to just come agreement with the contractor?
I think, you know, going back to, it's the short form you're looking at, the ECSC?
No, it's the NEC 3. It's option A. It's the full. Right.
Okay, so yeah. I mean, for me, looking at it, you'd say, well, actually, were they providing the works in that period? Bearing in mind that providing the works doesn't mean they have to actually be physically digging holes. Providing the works could actually be, you know, a stopped period of time. You know, there could be lots of reasons why the contractor's staff aren't working every minute of every day. It may be they're waiting for deliveries to arrive. It may be there's bad weather, which means they can't do certain activities. Maybe it's below a certain air temperature or it's heavy rain. So I don't think we expect that somebody is going to be working every second of every day and 100% utilised. So I think there has to be some degree of reasonableness here around, well, you know, they were providing the works in the sense of complying with an instruction to stop work. There was a period till the furlough scheme could kick in. So I would suggest that that's still providing the works in that period. You know, if it went on for 6 months before they furloughed, that's when you're going to get a debate about, well, what duty to mitigate, what is a reasonable sort of period of non-working before you start to not pay these costs. I think the challenge you have with NEC 3 that we've already touched upon is that issue around within the working areas, which could pose an issue that if they were then, you know, demobilised from site during that week, then they're not within the working area, and yet that is a requirement for inclusion as part of the costs under people in NEC 3. And that's where maybe there needs to be a conversation with the contractor on how to address that particular issue.
Thank you, that's helpful. Thank you.
Okay. We could have another couple of chat point coming in. Richard Patterson, should NEC 5, who says there's going to be an NEC 5? What's wrong with 4? Should we include a clear compensation event for a pandemic announced by World Health? Well, we've got to be very careful when we start drafting contracts on the hoof. We miss all sorts of things. So let's just take the COVID-19 issue. There's a long time when people were aware there was a serious problem in this country and elsewhere with this before it was declared a pandemic. So how do we deal with that? I'm not sure we need something specifically for a pandemic as opposed to maybe half a dozen or a couple of hundred different things that maybe you might think of as fitting perhaps within Clause 19, but let's deal with them separately, shall we? I'm not sure we wanted to do that necessarily. Rob Gerard, are you sure 61.6 is written for cost assumptions only? Well, I don't think it is. Cost 61.6 is any assumption, and we've already talked about an assumption about when something might happen. So it's giving time assumptions as well. So we say that assume that it will take 6 weeks before this is lifted, and it's lifted after 4 weeks. If it's changed to 4 weeks, then it's a fresh compensation event, and you assess the cost impact of that, bringing back that 2 weeks, if there is one. But all we're saying is that you can't actually reduce the date of completion at the same time. You can do that only through the acceleration clause.
Yeah, I mean, but Rob, by all means, chip in if you'd like in a moment just to share any further thoughts on that. But yeah, I agree with Peter there that it may well be you state assumptions about time and cost, or around, you know, issues around even productivity. You could put a lot of things down as potential assumptions. You know, too many, it gets very cumbersome to manage going forward. But it may be you assume a time and that time changes. That could be a new compensation as a result of the change in time. But when you come to assess the impact on the completion date, then you would not look to reduce that, even if the compensation event was negative and time could be saved. But certainly you would take that into account with the money. Do you want to add anything, Rob, or has that covered the question for you?
Rob is quiet.
He's put his hand up. Rob, you got a question to ask in addition? Just unmute your microphone.
There you go. Put my hand up. I was playing the game properly. Put my hand up, wait to unmute and everything. I agree you can have assumptions for all sorts of things, but it seems to work very well, doesn't it? That if you say assume it, or we all agree, or it's reasonable to assume that the delay to plan completion will be 3 months, and it turns out to be 2 months, then why couldn't you bring forward the completion date accordingly? I'm well aware that in any normal compensation event, the word delay sits in clause 63.5, so you only ever assess the word delay. However, if you read 61.6 together with 63.5, I think it's arguable that, you know, surely it's very sensible, isn't it, to get somebody to price on the basis of 3 months and then bring it back to 2. Seems to work for me. That's all I'm saying. It seems to work quite nicely. And sure, under 12.3 you can do anything, but
I think you don't need 12.3 because you've got clause 36, which deals specifically with it. And it's difficult to suggest that the project manager can make a unilateral decision to shorten the period for completion, which has just been agreed. So you've had a compensation event, you've agreed a 3-month delay to completion. And I think you're suggesting that the contract allows the project manager to unilaterally say, yeah, I have decided, and here's my calculation, my quotation for it, because you didn't give me one, which now shows it you taking 1 month less to complete the work. I don't think the contract provides for that. And I think clause 36 of the contract expressly provides for the parties agreeing that we'll draw back that 1 month, and the process for it is different. It's not something that can be decided by the client, by the project manager, irrespective of what the contractor thinks.
yeah, I was thinking there's total harmony between contractor and project manager and reasonably allowing for 3 months.
If there's total harmony over the 1 month change, then no problem, because 36 allows it to happen.
Yeah.
Yeah, and the contractor can propose it.
Yeah, you get the money back anyway. You get the money back, you generate terminal float, but why do you really want to generate terminal float? But anyway, it's arguable.
Yeah.
Okay. Thank you. Ross, I noticed you've posted a question there, a little bit of a long question around impact on the term service contracts. Maybe for the benefit of everybody, if you're happy, could you just maybe articulate that question verbally? If you don't mind just unmuting and ask the question. I think it's worth having a little bit of a debate around.
Yes. Can you hear me, Ian?
Yes,
Yep.
Can indeed.
Good. Okay. The term contract, because it doesn't have a prevention clause, has slightly different problems, it seems to me, and particularly has the problem which I've had mentioned to me by a number of contractors, where they're used to the concept of, oh, I can't do a piece of work in this room, so I'll go and do a piece of work. I'll move my staff somewhere else. But I had a particular contractor that was cleaning schools, and of course the schools were shut down completely, and yet they still had an obligation to go and clean them. And if they did go and clean them, they weren't dirty anyway. What was the point? So they had clients that saying, I've got a contract to have rooms cleaned which I don't need cleaning, and if I instruct them not to go and clean it, I'm changing the contract. And it really was just issuing around, was the instruction, for example, to close a school by central government or local authorities, making it impossible to go in and clean? And the parties were just uncertain where it all sat. Now, clearly, one answer is the parties all sit down and talk to each other, which it clearly is where you start. But the reality is that for term contracts, the whole world has changed, and yet we know that in many cases term contractors have stepped into the breach, particularly cleaning contractors have stepped up to the mark all over the place. But in this case, for some of these, looking after tower blocks, looking after office blocks where all the staff have been sent home, there's a whole stack of work that's no longer needed. But the contracts are a bit difficult to know quite how to handle it.
Yeah, interesting. I mean, we do have those different nuances around the service contracts. We don't have the prevention clause in there because they're not so time critical. It's for a fixed period. There's no sort of end date to be achieved. But perhaps there, clause 17.2 and the illegal or impossible requirements could come more into play. Is it impossible now to comply with the service? Is it possible to actually undertake that cleaning if the schools are saying no one's allowed in, or there's no requirement for it? So it could be that is more relevant in that situation, but impossible is quite a high threshold. It's quite a high test, as Peter mentioned earlier. I think it does come back to having the sensible conversations.
The conversation may end up by saying, let's remove some of the work from the scope, or the conversation may end up saying, look, there's this whole contract is put on hold for a period until we can do something more. So do we terminate, or do we just stand back and pause? So that clause 15 meeting will sort out what you're going to actually do. The project manager, the service manager, they will then take control by perhaps changing the scope, or client and contractor may agree that the right thing to do now is just to end the contract.
I think there's a certain degree of concern amongst some of the contractors of where they're going to get payment for the redundancy payments, because if you're closing a contract down which was using 300 cleaners and you haven't got anywhere else to put them, you've got a fairly high redundancy costs. Yeah. And I know furlough protected that to a certain extent, but they're not highly skilled construction workers which people are holding on to in many of these contracts. And I think many employers were getting quite worried that there could be some fairly heavy costs coming their way. And they've got to go somewhere. It's just a matter of balancing it all out. Yes,
there's a cost of redundancy, or there's a cost of retaining people until you can reuse them again. So yeah, there's a balance to be drawn. I think it's a conversation, as Ian says, you have to have on the contract to say what is the sensible thing. What do we want to happen? Yeah.
Thank you.
Something here from Sanjay?
Yeah, if I'm reading that right, I think Sanjay's saying that actually when they went through that process of looking to restart work on the back of a assumed period of suspension, they were able to pull it earlier, and they agreed an earlier completion date. So that's possibly giving some sign of what Rob was saying, where you can do that and you could use the assumptions to address time as well as money, and even the completion date if there's mutual agreement to do so. Whether that's under clause 36 or not, I'm not clear, but it seems that they were able to actually, recover that delay period and agree a change to the completion date to an earlier time. A question here from, is it Joe?
Joe.
I'm trying to work out whether first name, second name in order on how it's been shown on the screen. I'm going to drop to the second part of the question first, rather than come back to the first part. But question being asked here around, you get Z clause amendments to clause 6119 to make it time only, and the suggestion that as prevention is totally unforeseen, why should the client take all the time and cost risk? It's an issue that's been raised before. Your NEC is maybe different to other standard contracts where you get a prevention or a force majeure type event. Most other contracts would say contractor gets time but no money. The client doesn't get to levy delay damages, but they don't have to pay anything towards the extended prelims or whatever. And the idea being that's a fair allocation of risk that both parties take a bit of a hit because it's nobody's fault. In the NEC, we've always approached this differently because the key thing is it's linked to the ability of the project manager to give instructions on how to deal with it. You know, where you have a force majeure provision that says contractor, you'll get time but no money, then the contractor is going to want to look at options that give them the least cost and potentially increases delay. They're not going to want to, you know, be instructed to do things that would not going to get paid for in terms of money. So we've always said we're going to give the project manager the power to instruct how to deal with the issue. The contractor has to comply with those instructions, but the contractor will be compensated for the time and cost. You know, ultimately, it has to be a delaying event, as we've discussed, to fall under prevention. And it may well be that, you know, if there's no money involved, it's just there's a period of suspension, you would get time and no money. But if there's costs incurred, you're going to get those. But that comes back to the ability to instruct how best to deal with it. Anything to add, Peter?
Yeah, there's also the point that with any issue that hits the contract, there's going to be an impact, and the impact can be both time and money. And the question mark is how you deal with the balance between the two. Does the client want to have the contract brought forward in terms of time, minimum time, even paying more money, or is there a shortage of cash and we'll let it go longer if that's going to save money? Now, who takes that decision? If you simply have a clause which says you can have time but no money, then the contractor's taking that decision, and the contractor will take the decision which is the least cost to the contractor, irrespective of what it means and the impact on the client. The project manager's lost control. And what we've always said in the NEC is that we want the project manager to be controlling how the job goes forward in the interest of the client, balancing time and money. So every compensation event allows the project manager to ask for different quotations to deal with different issues, finishing more quickly or spending less money. So that's one of the other things about NEC, which is different from other contracts, where the project manager has that control, and we wanted to retain it when you hit something like a COVID-19 issue. Project manager decides, after discussing with the contractor the best thing, project manager decides the right action rather than the contractor deciding what they want to do in their own interests.
Yeah. And you can imagine the arguments or debates afterwards if the contractor does what they think is appropriate, but the project manager or the client thinks it wasn't appropriate. You can have lots of arguments afterwards over what course of action should have actually been undertaken. What we're saying is let's avoid that, agree or instruct as the project manager the way forward, and there's clarity over that. Joe also in his question raised said that a lot of contractors are requesting amendments to clause 19 or 60.119 to specifically account for COVID or who recognised pandemics. I'm guessing that's probably on contracts going forward or new contracts. I mean, it comes back to what you mentioned earlier, Peter, about how to deal with it in future contracts. Would you see that as a way to go?
No, because it doesn't really help at all, because the issue is, do you see that something is going to happen in the future? Do you want to allow for it? If you've got a clause which already deals with issues such as COVID-19, then you don't need another clause, another amendment which deals with that. If you're looking at a future contract and we're saying, well, we want to allow for pandemics, well, they've already happened. So how do you want to allow for it? So I think that it needs rather more thought than that. Existing contracts I would leave well alone, and for new contracts you need a lot more than just simply saying we'll call it a compensation event.
Again, it comes back to giving the contractor some basis on which to price and to assume they're going to have to work on the basis of, otherwise they are going to take, you know, a guess at it, and there could be some real consequences for both parties if they get that wrong.
Ian, do you want to come back on Sanjay's point about the cost of redundancy and fees?
Yeah, I think Ross has also jumped in there as well around it depends on the particular contract you're dealing with, and which schedule of cost components. We do actually have in the ECC, in the full schedule, a reference under people to, redundancy costs being part of the claimable costs. I mean, they have to be related to work under the contract. So there can be conversations around, if somebody's been with a company for 10 years and they're working on your contract for the last year and then they're made redundant, do you pick up any costs of that redundancy if they were already employees before the date you awarded them the contract they're currently on? Or do they take sort of 1/10 of the redundancy costs because for 1 year of their employment they were on your particular contract? So I think there's something that's probably, you're going to have to have conversation and look into some of the detail behind it. What would your view on that be, Peter?
Sorry, I was reading another question at the time, so I missed that last point. Beg pardon.
Yeah, so it's like actually we have touched on before, which is around redundancy costs. And if you look to the schedule of cost components, when you look at some of the things that can be claimed, NEC 4 ECC main schedule, for example, includes as one of the cost component items severance.
Yes.
So if somebody's being made redundant, then the severance costs could form part of the defined cost. But then you have that question over the costs have to be related to work under this contract. So if somebody was already employed before they started work on this contract, would severance be related to this contract, or just the fact that the contractor, wasn't losing out on some of their, lost other jobs anyway, just wasn't doing very well as an organisation? What proportion of somebody's redundancy costs should you pick up? And I gave the example that someone's there for. Sorry, go on, Peter.
No, give me the example if you want to finish.
Yeah, so I was going to say, so if somebody was there for, say, 10 years working for a company, and for the last 1 year they were on your particular contract, and then they were made redundant, the suggestion would be that you would have to take 1/10 of that cost, because that was the proportion that was incurred, if you like, on your contract based on a long service and amounts of redundancy costs increasing over time.
Yeah, it's always difficult to give a definitive interpretation of how to apply the contract, because there's bound to be a lawyer somewhere who will tell me we're wrong. But the way I would see it is to say that this person who's employed on your contract, if your contract hadn't been there and they had no other work, they would have made that person redundant, and that would have cost a certain amount of money. At the end of your contract, they now have to make this person redundant, and that costs a certain amount of money. And I would have thought the correct approach would be to say, well, the difference between those two sums is the cost of redundancy related to work on this contract. But as I say, there could be other ways of looking at it, and I'm sure there's somebody somewhere will tell me I'm wrong.
Yeah, I think, we do have it in there as an item. So we have a starting point that severance that is a claimable cost, but then you have to go through the other, parts of the schedule. Is it related to work on this contract, etc., to try and ascertain what that amount would be? And again, you may have to look to the requirements of local law, of the law of the contract itself, etc., to make a decision on that. Okay, have we got any other questions that we've missed? Yeah, that's a question just come in.
Ross has got one.
I think Ross is commenting on the issue about severance. If you have people rates, so in the short schedule of cost components, you have people rates, and those are in effect all inclusive of those items that are not either covered by the fee or by other items in the short schedule. So redundancy may well be built into that. Whether a contractor chose to include that in their build up or not is obviously their commercial decision at the start point. Okay.
Question Stephen Knock. Then there's Donald Morrison's got something there. Stephen's got a nice point there that says that you've stated assumptions, you've sorted out a completion date, you've realised that the assumptions were over optimistic and the contractor can finish earlier. Does that mean the contractor gets a bonus for early completion? Well, I think so, yes. That's one of the ways the contract works.
Yeah, that is the requirement of the contract. That's how it would operate in that way. Again, you could try and maybe talk through, clause 10.2 mutual trust cooperation. You could maybe look to clause 36, but there would be a requirement to mutually agree that. I think what may happen in reality is people may be slightly pessimistic in their assumptions about delay, go for the shorter period rather than the longer period as a result. But really, the idea is it's hopefully an informed conversation. The assumption, and again, there can be discussions around those assumptions as part of that quotation process. What is a reasonable assumption? If the contractor is working to a revised date, maybe they couldn't have remobilized earlier. Maybe even if you give an instruction, actually, it's not a 6 weeks delay, it's a 4 week delay. They couldn't remobilize their people. They couldn't get people back to site. They couldn't get, the social distancing in place on site in time. So you do have to look at it as the bigger picture. But yeah, you could have, that could lead to that situation. But at the same time, the assumption was meant to be a realistic and sensible assumption at the time. If it proves to be incorrect, well, that's what's going to happen. It could be that, it cuts both ways to an extent, because when we get contractor pricing it without assumptions, they've got to make an assessment of what they think impacts will be. And if we find out that they prove to be wrong later, that wouldn't be a CE if it's the contractor who's having to allow for those variables in their pricing. So, assumptions should be the best, based on the best information available at the time. Donald, if you've got a question you'd like to ask us?
Hello, yes, Donald Morrison, Highland Council. We're running NEC 4 contracts. Option A. We've had a standard seg clause for a number of years defining clause 19 and 60.19 events. So in other words, we're given a list of events that are defining these are simply, well, war, civil war, rebellion, revolution, insurrection, military or etc., strikes, riots. None of them mentions the current COVID situation. So we're trying to hang our hat on that seg clause. Is that wise?
Mm-hmm.
In other words, we're trying to do. Some years ago, we defined what the events would be for a clause 19 and clause 60.19 event.
Yeah, I guess there's two things. I mean, obviously, interesting approach in the first instance, trying to define what is covered by clause 61.19, because really the idea behind it is to cover for things that we don't know about. We don't define it because we don't know what it is. It is literally something that neither party could have foreseen, neither party can prevent, and causes the works to be stopped. So it almost defies definition, because it is there to cover for things that we don't know about and we can't define in advance. It could be that if in future people make a decision over who's going to carry the risk of a pandemic, and someone can either amend a contract to make that a contractor risk or exclude it from what would be prevention, or to make it specifically a compensation event. As we've discussed already, that's probably a dangerous thing to do, and you've got to think carefully about it. But the whole idea of prevention is for things that we don't know what they are, therefore we can't define them. So we have this, force majeure type wording within prevention. Once you have defined it, though, then obviously if that's what you're working to, then you're going to have to look and see whether this event falls within your definition. If not, it could still be a compensation event if in Scotland there was an instruction to stop work. It could be there's an illegal or impossible requirement now because the law was changed to say you can't work, so it became illegal to work. So, there may be other headings under which a compensation event could be claimed if you've amended clause 61.19, or I know some clients who remove it from their contracts, but that still doesn't mean that's it. There could be lots of other clauses and reasons as to why the event may still constitute a compensation event.
Yeah, thank you.
Yeah, I think what's happened there is that it seems like the clause 19 has been deleted and replaced by something which says only these events apply rather than the generality. Okay, so that's a change to the contract which has its own consequences. It may be that people haven't thought about the possibility that something like COVID-19 could come along. How do they want to deal with it? And that's, again, it's a point about changing contracts. If you think about why you're changing the contract, was it because we're saying, well, if something like COVID-19 comes along, we don't want to compensate, or was there some other reason for making the change? So it's all a bit of an issue in terms of design of Z clauses. I think that somebody probably has written a Z clause in the contract because that's what they expect to see in a contract, and they found that the way that the NEC deals with it is different from what they expect to see, and therefore they change it. So just going slightly askance from this topic, it's just about caution in terms of how you draft Z clauses, why they're there and how you do it. We've given some guidance actually in the guidance manuals about how to go about doing it for those people who want to do it, and maybe you need to pay more attention to that when or your lawyers do when they're drafting clauses for you. Not yours particularly, Donald, but in general.
I think the drafting's down to me.
Well,
I'm not a lawyer.
It may be that you need to think about, well, what were you trying to achieve by this change, and have you achieved it? That was my message to it. I've got this phrase which I use when you're writing a Z clause. Starting point is, what is the mischief that could happen that the contract doesn't deal with? And that is the starting point for any Z clause. Sorry, we've gone off piste here now.
Yeah, sorry. Thank you.
Have you picked up on any more questions? We've got a couple of minutes left.
Yeah. Okay. So there's another question from Joe to pick up on, and there's another question that's just come in from R. Rowlinson that I don't necessarily quite understand. So I don't know whether R. Rowlinson could maybe add some more to that, or maybe put their hand up to ask that question verbally. But just while we're waiting on that, coming back to the question that Joe was asked around test for prevention being its completion of the whole of the works, what happens to sections? The way the process works, in my mind at least, and Peter, correct me if it's wrong, is that it's like all the compensation events. It's a two-stage process. The first part is there or is there not a compensation event? So is there a delay to the overall completion date for the whole of the works? Yes, no, or there's likely to be, without any mitigation. In that case, you've passed the test for a compensation event. Once it's passed that test, the next question is, what is the impact? And when you assess the impact, in relation to any key dates, any sectional completion dates, as well as the completion date for the whole of the works. So once it passes the test to be a compensation event, then you look at the impact across all of those other aspects.
Right, Rebecca Rollison, have you got? There's a bit more comment come in from.
Yes, great.
Okay, additional client liability. We call that. Yes, but what exactly is the liability you're trying to cover? That's the question mark. I think it's a thing I've mentioned in the bit I was talking about how you modify future contracts. Just simply saying COVID-19 is an additional liability doesn't help, because it's a question as to what is the consequence of that. What are we trying to deal with? When things change, what happens?
Yeah, I think it's also worth noting as well, obviously, NEC 3, if you wanted to introduce another compensation event, then you would tend to do that by making it a client's liability, which would mean it's a compensation event, but also would mean that the insurable risk would transfer to the client or the employer in NEC 3. In NEC 4, you have the choice now of saying it's either a client's liability and therefore a compensation event, and the client will take the insurable risk, or you can make it just a compensation event where it's a compensation event, but the insurable risk still sits with the contractor. So you do have that choice about whether you do make it a client's liability or just a compensation event in NEC 4.
Yeah.
Okay, we are pretty much on time. Hopefully we've answered the majority of questions that have been asked. Apologies if we didn't get around to answering your particular questions. If you are members of the NEC users group, we have a helpline that you can use. So, don't forget that's there as a resource available for users to get access to. So any questions that maybe have been remained unanswered, that is a route to maybe get a response on those. Okay. So just to close out then, the conference restarts again tomorrow at 9 AM with a series of UK case studies. And then tomorrow afternoon, there's another workshop. And then Wednesday, back to 9 o'clock first thing for international case studies, and again a workshop later on Wednesday. So hopefully that's been of help to you. So say, by all means, do ask questions to the user group outline if you have anything further to ask. Peter, anything to add before we close out?
No, that was very helpful. There's some useful points made and some thoughts there that we've got to go away and just make sure that we've got everything quite right. So it was a very helpful session. So thank you for your contributions. It was very welcome to us.
Yeah. Great. Peter, thanks for your input there. Thanks to everybody for the input and the questions. So hopefully it was useful, and hopefully we'll see you virtually tomorrow for the next part of the conference. So have a good rest of the day, evening, morning, wherever you may be. And hopefully we'll catch up with each other again at some point soon. Thank you.
Thank you.
Thank you.